undocumented, you're married to a U.S. citizen, you have a final removal order, and you want to know what the heck you can do about it. You can consider a motion to reopen. So in other words, once the case is reopened, you're still in removal proceedings. You might have relief in removal proceedings, especially if you're married to a U.S. citizen and you've been here for more than 10 years and you don't have a criminal record. That is 42B cancellation of removal, where you can ask the judge for your green card. That you have to show extreme and extraordinary hardship to your qualifying relatives. Not only your wife, but in removal proceedings, you can also claim hardship to your U.S. citizen children that are under 21 and unmarried, and to your parents who might have status, maybe lawful permanent residency or U.S. citizenship. And of course, your spouse would be a lawful permanent resident or a U.S. citizen. So there could be a really good idea to seek to reopen your proceedings, and then in the proceedings, you're going to be in removal proceedings, you can then seek relief in removal proceedings. But let's just say you cannot reopen your case. You've actually tried, you filed a motion, it was denied. Maybe you've reached out and asked for a joint motion to reopen as a matter of exchange circumstances, and they won't. So here is the solution. You're going to leave the United States eventually to consular process. And when you leave the United States, you're going to effectuate the removal order. What does that mean? That means that now you're going to have to stay out of the country for 10 years because that is the punishment for being ordered removed. But you can come back sooner than the 10 years if you get a Form I212 approved. So you can do that preemptively in the U.S. So you can do it at any time after your spouse files the I-130, or you can do it now before your spouse files the I-130. So in theory, you can file it right now so that you possibly, if you get picked up, you already will be in process to be forgiven for the removal order so you can come back sooner. Now, lots of people file the I-130 first, and then after it gets approved, they file the 601A waiver and the I-212, Form I-212, concurrently or simultaneously. Here's the problem with that. The I-130 must be approved before you can file the 601A waiver. So if you aren't in that process, you're looking at 14 months from now to get the I-130 filed, to get the 601A waiver filed. Now remember, the 601A waiver is for unlawful presence, so that when you leave the United States, you won't have to stay out 10 years. They're two different things. One is the punishment for being unlawfully present in the U.S., and the 601A waiver will cure that, and you do that before you depart. But the I-212 is something that you need, whether you do it here or outside the United States, to cure the 10-year punishment for the removal order, which is totally separate from the unlawful presence. You get me? So you can talk to an immigration attorney and possibly file an I-212 now if you're freaked out and worried that you might get picked up and removed. On the other hand, when you do that, you disclose your location and you might be worried about that. On the other hand, when you file the I-130, you're going to disclose where you live and your location also. So it's a matter of how much you feel like taking a risk. And since you already are a priority for removal, you should discuss this with your attorney as a possibility to either file the I-130 first and wait for that to be approved and do the simultaneous filing of the 601A waiver and the Form I-212, or maybe in your circumstance, you want to do the I-212 now and then work on the I-130 and get that filed. And you could possibly work on the I-130 and the I-212 and get them filed at the same time, although they go to different service centers. So the point is that if you have a removal order, don't bury your head in the sand and think that I'm not going to be picked up and removed, because you could be. Let's just say hypothetically, you do the I-130, you do the I-212, and you're unfortunately picked up and removed from the United States. Those things aren't lost. So in other words, even if you get removed, the I-130 is in process, and the I-212, which you're going to need, is already been filed and it's in process. You don't lose anything. Now, in that situation, let's just say the I-130 gets approved and the I-212 gets approved, you still need to consular process, go to the consular officer, and then they're going to say, sorry, you need the 601 for the unlawful presence, in which case you have to file a 601 to cure the unlawful presence. You would have had the chance to do that in the United States, but you ran out of time. In other words, if you hadn't been picked up, the I-130 would have been approved. You would have filed the 601A waiver, which is essentially the same thing, but it's called the 601A waiver because it's a provisional waiver that you file in the United States before you depart, before you actually trigger the 10-year bar, which you don't trigger until you step your little feet outside the United States. I know this is a lot to take in, but these are important messages that I'm sending my followers and to anyone else that wants to understand that there is possibly something that you can do right now if you have a removal order and you cannot reopen your proceedings. Like, share, and follow. I'm Gloria Cardenas, the Immigration Queen.